Good afternoon, everyone. I'm Russ Harrison, Acting Managing Director and Director of Government Relations for IEEE-USA in Washington, D.C. And this is a special legislative update from Washington, where it is an absolutely gorgeous fall day, perfect temperature, blue skies, and just a wonderful time to be in Washington, which has nothing to do with the fact that all the congressional folks are gone. So when we originally scheduled this particular update, we were planning on, I scheduled it sort of as a warning and sort of to give the consulting community a heads up about something that was coming. The word on the street here in Washington was the Department of Labor was planning to update the rules defining independent contractors and consultants to impose the ABC test from California's AB5 on the entire country. The Department of Labor had said a few things that suggested that. We'd heard it in the media. The rumors around Washington were that that was coming, and that was concerning. An informal poll of IEEE members in California shows that about 20% of our consulting members in California have been adversely affected by AB5. And the DC rule would have been worse because you can't escape it by just moving to Nevada. So we were worried that that was coming. We knew that a rule change was coming. And so we scheduled this webinar. And just to accommodate us, exactly 1 week ago, the Department of Labor released this, which is their brand new independent contractor rules. And so instead of warning you what we think is coming, I will instead be discussing with you what actually came. And not to give away the punchline, but it is actually not nearly as disturbing as we feared. It's actually not that bad at all. But let's get into it. First, a couple disclaimers. I want to start by welcoming you all to IEEE Day. It's not technically today, but we're in the ballpark of IEEE Day globally. So we will wish you all a happy IEEE Day. As way of disclaimer, I want to point out that I am not a lawyer. Nothing I'm presenting here should be construed, viewed, or thought of as legal advice. I cannot comment on specific situations, contracts, or arrangements that you may or may not have in your professional life, and urge you, if you want to know how all of these rules affect your specific situation, I'm afraid you're going to have to contact an employment attorney to walk through the details. All of that is for two reasons. One, I'm not a lawyer, so I can't give you legal advice. But perhaps more importantly, the rules make it virtually impossible to decipher one particular situation and decide whether the individual in question is an employee or a contractor. It's more complicated. Let's get into that. So here's the problem we're dealing with. In 1947, Congress passed the Fair Labor Standards Act, which defined an employee. And that basic definition still stands as kind of the foundation of employment law in the United States. The Fair Labor Standards Act set kind of minimum working conditions in the United States, applied minimum wage to all workers, set maximum weekly hours, overtime, and a bunch of other kind of foundational ideas in the employment world. The Fair Labor Standards Act also acknowledged that there were professional relationships, business relationships between companies and individuals that are not employee-employer relationships. In other words, the law acknowledges that independent contractors exist. It doesn't really define them. And so ever since then, the courts and the regulators around the country have been scrambling to take kind of the vague language of the Fair Labor Standards Act and apply it to real-world situations. What we end up with is kind of a hodgepodge of legal decisions from courts all the way up to the Supreme Court and various regulatory bodies trying to figure out this gray area where you're not an employee, but it's not quite clear what you are. And that gets complicated. And so that's what we're trying to do here. The Biden administration is proposing a new set of rules to try to clarify the relationship between individuals who may or may not be employees and companies. I want to point out that the rules we're talking about today apply to federal employment law, not state employment law. So The rules the Department of Labor proposed will not change the situation in California. AB5 is still there, the ABC test is still there, but when dealing with the federal government, this is the rule that will apply, more or less. All right, so the exact political situation or sequence of events that got us here is a little complicated, so let me just walk through it. Otherwise, other parts of the presentation won't make any sense. In January of 2021, the Trump administration finalized new independent contractor rules for classification purposes. There is a set of criteria that the courts have developed over the years to determine if someone is a contractor or an employee, which we will be going through in a minute. The Trump administration created a hierarchy to try to guide courts as they decide who's what, and more importantly, to make it simpler for individuals and individual companies to figure out what was allowed and what wasn't. The law was finalized in January 2021, and it was set to go into effect March 8th, 2021. However, on March 4th, just before March 8th, the last administration, announced that the law would be delayed, and then on May 6th, formally withdrew it. However, on March 14th of this year, a court ruled that the withdrawal, the delay, and then the withdrawal of the rule was done improperly. And so the rule that went into effect on January 21st was deemed to be still in effect. And in fact, that rule is currently the rule that the Department of Labor uses. The new rules, which were introduced just Thursday, October 13th, will replace that Trump administration rule from January 2021 that was withdrawn but then not withdrawn, and is an attempt to explain and clarify the existing independent contractor rules. As I mentioned, the expectation was that this would be the ABC test. It's not. Not only is it not the ABC test, but the Department of Labor went out of its way to explain why it's not the ABC test, which we'll get to in a minute. I think that's politically important. So what we have now, specifically this, is a proposed rule. The Department of Labor is accepting comments until November 28th. IEEE-USA intends to comment in an attempt to improve the rules, but the rules would then go into effect sometime probably in early January, springish, depending on how long it takes them to go through the comments. So that is where we are. Quick comment on the ABC test, which is not what we're talking about. For those of you who don't know, AB5 was a bill passed a couple of years ago in California that said there is a very simple, straightforward test for determining if someone is an employee. The ABC test. We have three criteria, A, B, and C, not terribly cleverly named. And all three of these have to be true for an individual to be a consultant. Of the three, B is really the big problem for engineers. B says the services performed must be outside the usual course of the business of the employer. The problem is, first of all, it's not clear what that means, but it sounds like it means a company that produces software cannot hire software consultants, which is kind of a problem and has indeed proven to be a problem in California. So the good part about the ABC test, what it has going for it is that it's very simple. And it's relatively easy. It's not easy, but it's a lot easier than the criteria we're going to go through in a minute. It's easy to apply to a specific situation. So it's easier to use, it's shorter, and it's cleaner. The problem with the ABC test is that it is too simple. People have come up with almost an infinite number of relationships between an individual and a company or two individuals. The business world in 21st century America is so complicated that it is essentially impossible for three rules to govern it. As a result, the states that use the ABC test, California and a few other places, have a long list of exemptions, exceptions, exclusions for particular types of arrangements that don't work, which is why one of the reasons why we didn't want the ABC test used nationally, because once you add so many exceptions, the rules start to become irrelevant, and then that gets messy. Now, I mentioned a minute ago that the Department of Labor, in the rules that came out last week, specifically said they considered implementing the ABC test. They said they couldn't because of a Supreme Court case, Tony v. Susan Alamo, if you're wondering, which required the Department of Labor to use the economic reality test, which we'll talk about in a minute. Now, I mention this because by calling out the ABC test specifically and linking it to a Supreme Court case, it's actually going to make it harder if future administrations want to implement the ABC test nationally without congressional authorization. Supreme Court didn't rule that ABC was unconstitutional, just that it violated the Fair Labor Standards Act. So they would have to have a new law to implement it, which would make it harder, which is a good thing. So I'm glad they did that. Now, before we get into the details of the law, there are parts of the new rule. It's not a law, it's a regulation. The new regulation. There are parts of this rule that don't make a tremendous amount of sense until you understand what the objective is. The objective is to fix what this administration sees as mistakes made by the last administration, to clarify the law to make it easier to use, and to classify most gig workers as employees. And there are a couple sections in the bill and the law, in the regulation, that I'm going to mention as we go through this that are specifically designed to apply to Uber drivers. Now, whatever you think of Uber, that doesn't affect IEEE very much, and so we have no position on that, but that helps you understand the context of why things are written the way they're written. And we'll go through the details as we go through it. Now, I mentioned the economic reality test a moment ago. This is a rule used by most courts that says you have to use the totality of circumstances to determine if an individual is an employee or a consultant. And you have to focus on the real business arrangements in light of real business practices. In other words, if you have a contract that says you're a contractor, that's nice, and it may be helpful, but that doesn't make you a contractor. It's the actual implementation of the business arrangement that determines whether you are a consultant or not. Now, the economic reality test has the advantage of being very flexible. It allows courts to look at a given situation, a unique scenario, and decide how the rules can work, which gives, in a very complicated society, it makes it easier for a lot of different arrangements to be declared legal and useful, which they are. Unfortunately, it also makes it virtually impossible to say yes or no to a given question about the implementation of the rule. So as we go through the presentation, if you have questions, please enter them into the chat box. It'll pop up in my comment screen. I will rotate back to those at the end. But I'm going to warn you right now, in almost all cases, my answer is going to be it depends, because the rules are very difficult to apply to specific situations without lawyers yelling at each other for quite a bit of time beforehand. The economic reality test developed by the courts makes it clear that the bias is towards being an employee. In other words, you have to prove you're a consultant, and if you can't, you're an employee. But at least it allows the courts to be flexible, and it's very similar to the rule we've been using for the last many, many years, so people are at least familiar with it. And again, the answer to all of your questions is it depends. All right. Within the new rule, there are 7 criteria that the Department of Labor says should be used to determine if someone is an employee or a contractor. And I'm going to go through all 7 and kind of talk about the implications of them. But I want to emphasize, most of these are very similar, if not identical, to what came before the 2021 rule. So most of these are not actually changing things. They're just reverting back to what was, maybe clarifying and changing it in a few little ways, but it's basically the same. First criteria is the opportunity for profit or loss through managerial skill. Now, the opportunity for profit and loss has always been part of the criteria. The managerial skill is it's significant for some people, but it's a modest adjustment and clarification of the rule. The basic idea is, can the individual lose money on this contract? If you're an employee and you're hired to work on a particular program and the program fails catastrophically, generally speaking, you still get paid. If you're a consultant and you're hired to work on a particular project and you fail to deliver it, typically you don't get paid. That's the quick way of looking at it. The other way to look at it is, can the individual make decisions that increases or decreases the amount of money they make? These are managerial decisions, things like how and where to work. Can they set prices, which will come up again in a few minutes? Can they choose their clients? Do they make advertising and marketing decisions? Do they get to make material purchasing decisions that affect their bottom line? In other words, do they get to decide where to buy the raw materials for the product? And then do they have to live with the consequences? If they get more expensive material, do they then lose money? One of the things the DOL rule does very clearly is makes it explicitly clear that working more hours or accepting more work from a company does not change your status as an employee. So opportunity for profit and loss means, can you do your job better to make more money? It does not mean, can you do your job more to make more money? Simple hours doesn't work. And if you're paid by the job by your company and you take more jobs, thereby getting more money, that's not a managerial decision. And therefore that does not suggest that you are a consultant. It doesn't mean you're not, it just doesn't help you make that distinction. The decision should therefore be based on how you complete the job, not how long it takes you to complete the job. 2, investments. So who is spending the money required to get the job done? Is it you? Then you're probably a consultant. Or is it the company, in which case you might be an employee? I want to emphasize, by the way, these are not hard criteria. In other words, if you fail the investment test, it doesn't mean you're an employee. It's the totality of the experiences that determine the answer, not how you do on any one criteria. Unlike the ABC test, where if you fail one test, it's over. So investments, who's spending the money? The investments in question have to be of a capital or entrepreneurial nature. What does that mean? Are you investing money in allowing you, presumably the consultant, to do the job better, faster, or cheaper? And are you the one who paid for it? Investments required to do the job at all don't count. Specifically, if your job requires you to own a car, the purchase of the car does not count as an investment for the purpose of determining whether you're a consultant. Why did they do that? It's because of Uber. All Uber drivers have to own a car. That is a fairly sizable investment. Without making that exemption, it would make it easier for Uber drivers to qualify as a consultant, which is what the DOL does not want. Individual investments will be weighed against company investments. So in other words, if you're a graphic designer and the company buys you a computer and buys you an expensive software package to complete a particular job, and then you buy a pad of paper and a pencil to help you complete the job, the investment in the paper and pencil is not going to work because the investment in the computer and the software is much, much bigger. Now, in the case of technology, this gets actually quite difficult because if you're building a little doodad to put into a jet fighter, the jet fighter is going to cost a lot more. And if the particular doodad is going to cost a lot of money to produce, you, the consultant, isn't actually going to make it. You're just going to design it. And so there's some gray area in here that makes it difficult for consultants. It's one of the things we're going to ask for clarification on. Change from the previous rule, initiative does not count. That is effort. The effort an individual puts into the job does not count in determining whether you're a consultant or not. And the investment has to be specific to an individual's ability to make money, not their specific ability to complete a given job. In other words, if you invest in technology to help you do a job that can help you do other jobs, that counts to help you become a consultant. If you invest in technology to help you do the specific job with that specific company, but the technology can't help you with anybody else, that's a lot more problematic. Lastly, and importantly, investing in yourself counts, probably. If you pay for a set of courses that get you a certification that allows you to bid for many jobs at many companies, the investment in your own education and certification suggests that you are a consultant. If, on the other hand, you invest in training so that you can learn to use a software system that is proprietary to one company, that does not count. That actually suggests you may be an employee. The trick is the knowledge that you're gaining marketable? Can you sell it to multiple companies? You don't actually have to, although that does help. But the question is, can you? And if you can, that suggests that you're a consultant. Degree of permanence. How long and how often do you work for one specific company? Again, this is not a yes/no question. It's a suggestion on which way things should fall. Intermittent. So the idea is if you work for one company all year long, especially if you only work for that company, regardless of the nature of the business arrangement, there's a strong chance you're an employee. If you work for one company every April for many years in a row, even though it's not a year-long commitment, it's an intermittent commitment, that still might suggest you're an employee. What the DOL is actually getting at in that particular rule is people that go around harvesting crops, sharecroppers, where you might work for one farm for 2 weeks every single summer. Well, that suggests that you are an employee of that farm, even though it's only for a couple of weeks. The underlying theory here is that contractors usually work for a defined term, a defined period of time, and employees generally don't. And so if you have a fixed amount of time you're working for someone and then you go away, that suggests you're a consultant. If you have a contract that's 6 months, but it is renewed regularly or renewed automatically, that may suggest that you're an employee. Significant to this particular regulation, the Department of Labor clarified that having more than one job does not mean you are a contractor, nor does it suggest that you are a contractor. It is the nature of each one of the jobs that matters, not the fact that you have many of them. So if you could theory work for 3 different software companies as an employee of 2 of them and as a consultant at the 3rd. That gets complicated and you wouldn't be able to sleep, but it is theoretically possible. Number 4, degree of control. This has always been kind of the heart of this conversation. Contractors should not be supervised. The basic legal idea here is that if you are a contractor, you are given an assignment and then you run off and do it. How you do it, when you do it, where you do it is entirely up to you. And then you bring the finished product back to the company, and that's the arrangement. The more the company pays attention to how you do your job, the more likely you are to be classified as an employee. Key factors include scheduling, hours worked, supervision over how work is done, the right to assign work to other people, the right to decline work, all of which are part of the totality of circumstances that need to be looked at. A key part of degree of control has always been the legal and practical right to work for other people, especially if those are competitors. If you, in fact, work for 2 software companies who compete against each other and they know it, there's a strong likelihood you're a contractor, not an employee. If you are not allowed by your contract to work for other companies, or as a practical matter cannot work for other companies, that suggests you're an employee. For example, if you have a job that requires you to be somewhere from 9 to 5, Monday through Friday, as a practical matter, that's going to make it very difficult to have a second client. That suggests that you don't have a client, you have a boss. Significant to the new rule is a section on the use of technology to monitor or control employees. Additionally, there's language in here making it clear that companies may exercise control over employees or exercise control in a way that causes an individual to be classified as an employee, even if doing so is required to make sure that the individual is complying with safety, legal, or other obligations. Now, why would you do that? Wouldn't you think the company would need to keep track of whether their consultants are following the law? It's Uber. Uber tracks the driving habits of their drivers to make sure they're driving safely. The DOL is saying that because Uber does that, there's a greater chance that the drivers are employees of Uber, not contractors. By the way, you get around this problem if you are a company by asking your consultants to provide you a certification that they complied rather than checking to see if they're complying with the law themselves. In other words, that they just give you a document saying, yes, we swear, we promise, we complied with all these employment laws, you're good, and the individual in question is more likely to be decided to be a consultant. Another key part of control is the right and the ability to set prices, to negotiate wages. There are no conditions under which you are absolutely, totally, certainly a consultant. But you get sort of close if you work for multiple companies that compete against each other and you're paid slightly different amounts of money for doing essentially the same work, because that shows that you negotiate prices. Those are the kind of factors the courts would look for here. Integral part of the employer's business. This is the B test. And this is the part of the new reg that is most concerning. If you work on work that is critical, necessary, or central to the employer's business, there is a presumption that you are an employee, not a consultant. Now, the difference with the ABC test, to be clear, is if you fail the B test, you're done. You're an employee. That's the end of the conversation. If you fail this test, you are not necessarily an employee because it's the totality of experiences, and you can have other factors weigh towards being a consultant that outweighs this. But it's hard to tell how that's going to work out until the courts take a look at it. But in general, the Department of Labor is saying they will be skeptical of individuals that provide services without which the company could not function, even if that service is a relatively small part of what is a core function. This is a problem because technology consultants often do very specialized work without which the company could not produce whatever it is they produce. You think somebody who builds satellites and just builds one particular piece of a satellite. Well, but without that piece, you don't have a satellite. So it is critical and therefore is an integral part of the employer's business. But they still may be a consultant if they work for multiple companies, they work on their own, they set their own hours and meet all the other criteria. But this is a difficult one for a lot of IEEE consultants to meet. On the other hand, number 6 is not. This one works in our favor. The general idea is the more skill required to do a job, the more likely you are to be a consultant. Now, that's not dispositive, of course. There are other factors that play. All the other factors come into play. But in general, the higher skill, the more likely you are to be a consultant. The new law makes it clear that the skills need to be used with business-like initiative. In other words, it's not merely being skilled. It's used in a way that allows you to decide how to solve the problem, whatever it is that you were hired to do. Specifically, learning a skill to meet a specific company's needs actually suggests you're an employee. Learning a skill to meet several companies' needs, that is, developing a skill that you can sell to multiple companies, that is, in the DOL's opinion, exercising business-like initiative and suggests that you are a consultant. So the skill ought to be useful to multiple companies. Again, learning how to use a proprietary piece of software does not necessarily help you prove that you are a consultant. It actually argues for you being an employee. Now, of course, if you know multiple software packages, one of which happens to be proprietary, that's an entirely different matter. But the fact that you have skill in a proprietary software package does not help you become a consultant. What happens if you have to be trained on a skill? Well, the question is who pays for it, who can benefit for it. If you receive training to do something that only one company does and the company pays for it, that suggests you're an employee. If you purchase training to learn a skill that multiple companies could theoretically buy from you, that suggests you're a consultant. You don't necessarily have to sell to multiple companies, although that does help. The fact that it is a marketable skill weighs in favor of being a consultant. The next part of the process is, does the individual exercise independent judgment? This goes back to earlier criteria over control. Does the individual get to decide how the given challenge should be solved? The section also specifically says that driving does not count as a specialized skill. That's Uber. Actually, in this case, I think the DOL is right. The fact is, almost everybody in American society can drive. It's not really a specialized skill. It's sort of like being able to read. The fact that you can read does not mean that you have a specialized skill that suggests you're a consultant. You may be a consultant. You may be a consultant if you can drive. But the fact that you drive doesn't make it more likely that you're a consultant. And number 7, other. That's helpful. The DOL put this in here just to remind the courts that, again, the courts should look at the totality of a business arrangement. And again, this is a very complicated country. There are lots and lots of very unique arrangements people have worked out with companies. There may be other factors that the Department of Labor hasn't thought of that in fact are pertinent to determining if you're a consultant. And so they put in the other category to allow it to happen. But there's a section in here that is particularly important to technology consultants. Specifically, the DOL says that being incorporated, that is, wrapping a legal shell to create a business out of your consulting work, does not suggest that you're a contractor. It doesn't hurt, but it doesn't help either. The Department of Labor believes that that reflects mere labels and does not necessarily say anything about the real relationship, the real business interaction between the individual and the company, and therefore it does not matter. Now, this is significant because in California, one of the ways to avoid the ABC test is, in fact, to wrap a business around your consulting, to incorporate, to become a sole proprietorship, whatever. But by becoming not an individual, but a business that employs an individual, you can avoid the ABC test. You cannot avoid the Department of Labor's rules as they were just written. Which again emphasizes the primacy of actual practice and actual behavior over contracts and agreements. Doesn't really matter what your contract says, it matters what you do. So we have the 7 criteria. There's no rule that says you have to pass 4 of them. There's no rule that says if you fail 3 of them or 2 of them or any one of them, or even if you fail 6 of them, that you still can't be defined as a consultant. These are just things the courts ought to look at with some guidance on how they should be weighed and how they should be evaluated. But there's no real prescription on how to put them all together. Of the 6, as I mentioned, I think 2 of them weigh pretty favorably towards IEEE consultants, and one of them is a problem. The investments, because IEEE members tend to be very highly skilled, they have in fact invested in their education and their training, which does suggest they're consultants, and they have, as I said, they have high skill and generally take initiative, business-like initiative, both of which makes it easier to be labeled a consultant. But the integral to the company's business criteria is problematic. So what does all this mean politically? Well, I think it means that the Biden administration is acknowledging that the PRO Act is dead. The PRO Act was a pro-union bill that the House of Representatives passed last year. It had 47 co-sponsors in the Senate, which was all the Democrats but 3. And the theory was as soon as the 3 additional Democrats signed on, the bill would pass. It's not going to pass. It couldn't get those extra 3. It probably couldn't have gotten through the filibuster anyway. And the Democrats that control Congress appear to be almost out of time anyhow. If the Biden administration thought the PRO Act could pass, I don't think they would have mentioned the ABC test in the regulations, because they wouldn't wanted to call into question the validity of the act prior to becoming law. I do think, however, significant pressure was put on the Department of Labor to implement the ABC test, which is why they felt the need to bring it up and explain why they didn't use it. They didn't actually have to do that. The fact that they went into some depth on why they didn't use the ABC test, I think, speaks to the level of pressure they were under. Overall, the rules don't change very much from what they were prior to 2021. They don't actually change all that much operationally from the Trump administration rules. They just kind of clarify a few things. They get rid of the hierarchy. So you have 7 criteria. They all are equal weight, where the Trump administration said 2 were more important and 5 were less important. Operationally, I'm not sure how important that distinction is. Of course, the difference is gig workers will now be probably pretty clearly defined as employees and not consultants. The final rule, like I said, the proposed rule came out last Thursday. A final rule will be promulgated sometime next year. It will probably be very similar to the proposed rule. Like I said, it doesn't change all that much anyway, although the gig issue will be fought over. But from IEEE's perspective, we'll end up basically with this. We hope to make some little tweaks to it to improve it, but overall, it's not really all that bad, and something I think most of us can live with. And if that's not true, you need to let me know. So what's next? The proposed rule is open to public comment until November 28th, probably. IEEE-USA will be submitting comments. If you have things you would like us to say about this, let me know. My email address is r.t.harrison@ieee.org. I'll put that up again later. Please get me your comments before November 14th. Now, I said the comments are due on the 28th, which they are. The thing about the 28th, though, is it's the Monday after Thanksgiving. I think there's probably a pretty good chance that deadline's going to be extended into next year. But for the moment, this is what we want. I want the comments, I'm asking politely for the comments a little bit early from all of you, because there's a board meeting, an IEEE-USA board meeting on the 18th, and an IEEE board meeting a couple days after that, and then it's Thanksgiving. So I need to get them in early to get the comments written in time to have our volunteers take a look at them so that we can submit them on the 28th. If you like updates like this and find them to be useful, I'm encouraging you to listen in to the IEEE-USA legislative update. It's given Thursday at 1 o'clock, so this time every other week. Next week is the week that will provide you with up-to-date information on what's going on in Washington, what Congress is up to, and what the government is doing to and for America's technology community. Those updates are hosted by my colleague, IEEE-USA Senior Legislative Representative Aline McNall, who sits just a couple doors down. There's a website there to look to see when they are, but they are free to the public. They are posted on our website if you want to see old ones, and they're a very efficient way of getting a quick update on what's going on in Washington. All right, I'm going to switch to the comments in just a second, but before I do, I remind you my name is Russ Harrison. My email address is r.t.harrison@ieee.org. My email address, my phone number rather, is 202-530-8326. If you have any questions about this rule, the state of the proposed rule, employment and law in general, or anything to do with the American government, please feel free to reach out and ask. If you are also trying to get contacts within IEEE and trying to navigate the institution, which is admittedly quite big and quite dynamic, I'm a good point of contact to help you find your way around. And with that, we have a whole ton of comments, which is very exciting. I'm going to flip up to the top. Maryland, Don, yep. A lot of comments on AB 5. Yeah. We're pleased it's not going national, but yeah, there are some complications. And as my boss, Steve Welby, pointed out, California felt the need to pass an additional piece of legislation adding new professions to the list of exemptions. Last I checked, it was like 8 pages of exemptions, exclusions, special cases. Unfortunately, technology engineers are not one of them. It's something we're trying to work on in California. California is a tough state to work with, though. But AB 5 is a problem for that. And if the federal government were to adopt AB 5 as the rule, they would have to have this long list of exemptions attached to it as well, which gets really, really, really messy really, really fast. Let's see here. Opportunity for profit and loss. Exclude time and material arrangements. Well, it depends, as these things generally do. The general rule is, and again, the problem is there is such a variety of possible time and material arrangements. Some of them would suggest you're a consultant, some of them don't, some of them suggest you're an employee. The basic idea is if the individual can make decisions without getting approval from anybody that would cause the individual to make more or less money on that particular job, that suggests that they are a consultant. It doesn't prove it. Nothing, there's no yes, no question here, but it does suggest it. So if your time and material arrangement allows you, the individual, to make decisions that can save you money, increase your profits, or increase your costs, and the company has no say and has no ramifications, they're not going to make up the difference, that suggests you're a consultant. Adjunct faculty is a fascinating question, and you've asked me that before, and I don't know. That is something that I really, really want to add. Let me go back because you're all referring to numbers. So the basic deal here is that a lot of universities are treating adjunct professors as consultants, so they don't have to treat them as employees. My understanding is that there has been some pushback against that. Of course, the answer depends on what the exact relationship is, but I would think that that would be a problem. After all, the integral part of the employer's business is, in fact, teaching, at least in theory, unless you want to argue that research is the integral business, the core business of a university, which I don't think the university would want to argue. But Don, you and I have chatted about this. I do think adjunct professors are problematic under these rules. I don't think they haven't been challenged very much, but I think that they might be able to. Oh, thank you, Steve, for clarifying. I'd forgotten about that. Yeah, the California rule specifically exempted adjunct faculty. The thing is, the ABC test is used in multiple states, and I'm not sure they've all done that. The rule wasn't designed to look at adjunct professors, but I think they can get sucked into it. Yeah, I'm not surprised, Mr. Aranda, Miss Aranda, apologize. I think you should be confused about some of this. The fact is that there's a lot of gray area here. There's a lot of things that are not well defined. And what's happening here is the government is trying to create a rule that applies to sharecroppers and aerospace engineers and newspaper reporters and music performers, newspaper reporters and performers, and all, everybody in between. And that's hard to do with any sort of specificity. And so you end up with gray, and that's what you actually have. And the Department of Labor was trying to clarify it, but they can't get rid of the gray. The fundamental problem is the law. The fundamental wording that defines what an employee is doesn't define independent contractor. And without that real clear legal definition, everything else gets fuzzy, and that's unfortunately where we are. WK, what situation would business arrangements be questioned? So the situation where a business arrangement would be questioned is generally when someone complains. Usually the Department of Labor doesn't go out to find problems, although in some cases they may go out to find someone to complain if they think a particular business like gig workers is problematic. But usually it requires a complaint. The consequences of an individual who has been labeled a consultant being labeled an employee, and it almost never works the other way around, is the company ends up paying an enormous amount of money because they owe, back pay, and they owe overtime, and they owe, and there's penalties and all sorts of things. So it can get extraordinarily expensive. So the real problem with these rules isn't that people get reclassified, it's that companies stop hiring consultants to avoid the problem. And that's what we're seeing in California. The fact is nobody knows how the B test really should be applied to software engineers in California. But a lot of companies are assuming that they know there's a chance that software consultants could be defined as employees. And they know if that happens, it's going to cost them a great deal of money. So they're just not using consultants, or they're using consultants from outside of California, which is what's actually happening. And so the consequences of these rules actually have more to do with how companies behave on day one, rather than the enforcement, which may happen down the line. There have been a lot of enforcement activities. It tends to be lower skill work that gets picked up in this. Actually, if you look at the court cases involved, there are a huge number of adult entertainment facilities that are part of the court cases, which is interesting. But it's not the enforcement that really drives this. It's the company's anticipation of the enforcement. Unix dev, yeah, degree of permanence can be a problem. It depends. Well, I mean, that's always the answer, right? It depends. If you are doing the same project for the same company over a long period of time, regardless of anything else, that does suggest you're an employee. But we are regarding everything else. And so if you are doing a project with a company and then also doing more or less the same project with multiple other companies, degree of permanence suggests that you are an employee, but the rest of the arrangement suggests that you're not. And it's the totality of the experience that counts. And so you could still be labeled as a consultant. I can't tell you what your particular position is, but that's how the courts tend to view this. As I mentioned before, that's especially true if you're doing essentially the same work for multiple companies that compete against each other, and you're paid different amounts for each one of them, which shows you have control over your price, which is number 4, and says you're an employee. Oh, gig worker, I'm sorry. Yeah, a gig worker is kind of a term of art for Uber drivers, Grubhub delivery people, people that have these kind of casual part-time work arrangements with a company that delivers a service through these people, app-based work. Yeah, none of these things existed 10 years ago, I don't think, and now they're a sizable part of the economy. The Department of Labor is clearly trying to bring employment benefits to this classification of workers through these rules, and at the federal level, they probably will. St. James, I'm not sure what your question is. I will say this. The paperwork you use to pay an individual probably wouldn't weigh for very much with the Department of Labor if they're determining whether someone is an employee or a consultant. Consultants are paid, if I remember correctly, with a 1099. Employees are paid with a W-2. But the fact that you paid someone with a 1099 does not actually mean they're a consultant. You could have been wrong. This gets to the legal distinction as opposed to the real distinction. The Department of Labor is going to look at the business arrangement you have with that individual and to see how it applies with this criteria, not the actual legal arrangement that you have on the signed contract, which they're very clear does not have much weight in their mind. Let's see. Invention or copyright ownership. Say, James, I'm not quite sure what you're asking me. If you could elaborate a little bit, I could respond. Being a P actually helps you in California. There's an exemption for people with state-issued licenses in California that gets you out of the ABC test. In the federal standing, if you've paid to get your PE, well, first of all, being a professional engineer suggests that you have skill, which suggests that it kind of tilts things a little bit towards being a consultant. Of course, there are lots of highly skilled employees, so I don't think that's going to be that useful, but it helps. If you paid for your professional license degree, that will help. If the having a PE degree makes you marketable towards multiple companies with help, which helps. If you have marketed your services to multiple companies, that helps. If you are employed by multiple companies, that's a really good sign. So this stuff builds on each other. Having the PE is good, but it doesn't actually say that much about the actual business arrangement you have with a specific company, and it's that arrangement that matters a great deal more. But it helps, and in California, it helps a lot. Bob, I think the end of your question was cut off. Having multiple employers is health insurance. Yes, typically contractors don't get health insurance. But the fact that you do not get health insurance does not necessarily mean you are a consultant. In other words, if the company has declared you to be a consultant and therefore not given you health insurance, but you fail our 7 criteria test, then the company is going to have to pay for your health insurance. And there may be a penalty because they didn't provide it in previous years. So again, it's not the contractual arrangement that matters, it's the actual work that's being done that counts. And did I skip over somebody? John, it depends. If you are under a fixed price agreement where you could realistically and meaningfully negotiate your wages, that suggests you might be a consultant. If you are just being paid the same as everybody else, that suggests that you're not. And actually, hourly wages are the same thing. If you can negotiate your hourly wages, that suggests you're a consultant. And if you can't, it probably isn't. And again, it's not just the right to negotiate wages, it's having the practical ability to negotiate wages that matters. Lynn, good to see you. Let's see. Project manager. Project manager is self-paid, sets own fees, has to work with the corporate team, but can also have control of time. Yeah. Lynn, a colleague of mine here at IEEE, is correct. There are certain jobs that require you to work with other people as just a part of it's in the nature of the job, which would seem to make the control criteria problematic. Oops, missed it. Because now your schedule is kind of fixed and the hours you work are kind of set. The Department of Labor rules actually accommodate that the nature of the job is taken into account when determining whether you're a contractor or not. So for example, there was a case, an individual, it was an IEEE member that I spoke to, that did work on supercomputers. And he was only allowed to go into the facility with the supercomputer during certain hours, because that's the only time the company wanted to make their facility available to him. Well, that's exercising control over the individual. But the control is being exercised for reasons that have nothing to do with the employment arrangement. It's just the nature of the work. Also, you know, the individual with the supercomputer had to work where the supercomputer was. He couldn't, you know, take the computer home with him on the weekends. Therefore, the location of his work was set, but it was set by the nature of the work, not the company per se. And these kind of very fine distinctions are what make this really hard, and why it depends. Project managers can be consultants. They're not necessarily consultants. It depends. I think if the particular manager is working for multiple companies, that's a good sign. If they're being paid differently, even if it's only slightly differently by multiple companies, that makes it easier. If they've paid for their own training, that helps. So there's all these criteria which would apply to a project manager. The fact that the nature of the work requires them to be somewhere at a particular time is not actually that meaningful in the calculation. It's just that's what the job is. So bias towards materials. There's not actually a bias towards materials. That was just an example that was called out in the ruling that I thought helped make things clearer. A psychiatrist may charge per session, but there are no material goods involved, which is true, but doesn't actually matter. Because in this case, the service that's being provided is what you would look at. Is the psychiatrist would almost certainly be an independent contractor because they're not working with a company. They're working with individuals. So they have lots and lots and lots of clients. They set their own hours. They maintain their own office. So they would have probably limited difficulty complying. Of course, companies sometimes hire psychologists for their staff, so it gets complicated. But generally, that wouldn't be a problem. The issue is we're looking at the service provided. Now, in the case of psychiatrists, you'd also have to look at, in order to do that job, you need a certain education. Who paid for that? If a company pays for it, well, maybe they're an employee, but if the individual paid for it themselves or their parents or whoever, then that makes it easier to argue that you're a consultant. Is having 2 to 4 clients at a time enough? The answer to the question is nothing is enough, in the sense that there's no point you reach where I can say, or anybody else can say definitively, yes, you're a consultant. The law doesn't work that way, I'm afraid. But having 2 to 4 clients in different technology fields, all of that is a very good sign. All of that argues towards being a consultant. But I can't say you are. You'd have to consult with a employment attorney to get a specific ruling on your case. But even then, it's tough, because it's the totality of the experiences that have to be looked at. And there's a bunch of different criteria that have to be considered. But the scenario you painted there does seem like a very strong case. Seasonal examples are interesting. Tax consultants are a good one. The new DOL law, Department of Labor law, actually goes out of its way to talk about seasonal work. Now, most of the context for that is agricultural workers, which there's a sizable amount of the court cases in this case are the Department of Labor and Department of Agriculture stepping in to protect farm workers. So it makes sense that they cite those a lot. But it's quite clear that seasonal work could go either way. The fact that it's seasonal doesn't necessarily argue one way or the other. It's the rest of the relationship that matters. We get into the permanence issue. If you're, for example, say you're a mall Santa. Is a mall Santa an employee or a contractor? It depends. But if you are a Santa that works for exactly one mall every single year for multiple years, and you're paid the exact same amount as, I don't know what an equivalent employee would be, but if you and the elves and the photographer all paid the same amount of money, and that's just that may suggest you're an employee, even though you're temporary and seasonal. If, on the other hand, you're a mall Santa that works at multiple malls, if you negotiate a different salary with the malls each year, and if you're paid differently than the other people that you're involved with, yeah, maybe you're a consultant. It depends. John, the ineligibility for a benefit is the definition of a consultant, in the sense that once you've been decreed to be a consultant, you're generally not eligible for benefits. If you get benefits, that could actually be an argument that you're actually an employee. But the fact that a company has denied you benefits does not actually argue that you have been classified correctly as a consultant. In other words, if a company doesn't give you benefits, but you actually should be considered an employee based on all the other criteria, then the company's going to have to, it's going to be a fine, there's going to be back pay and back benefits and all sorts of unpleasantness. But it's not the contract that matters here, it's the nature of the work. Independent contractors, actually, that's an excellent point, Unix Dev. I don't believe that came up in the rules, but if a consultant screws up, they can personally be sued, where if an employee screws up, the company gets sued. And actually, that's the basis of some of the lawsuits in this space. Somebody was a consultant, got sued, and said, oh, no, I'm not a consultant, I'm actually an employee. They're responsible. I don't, this isn't how you want to find out if you're a consultant, I think. That's the key here. You want to know pretty surely you're a consultant before you get sued, or, avoid being sued entirely. But yeah, that is a key distinction there and could be a complicating factor. And the reason being sued is not a part of the test is because you can't really determine that beforehand. You can have an agreement with a company that says, if you, the individual, get sued, the company is not responsible. But that agreement doesn't necessarily make that true. And the only way you're going to know if it's true is if you're actually sued and you put it to the legal test. In other words, the existence of that agreement does not actually argue one way or another. It's the all of the business case that makes the difference. Healthcare is a big deal, Bob, for a lot of these guys. It's a big deal for consultants constantly. And it's one of the reasons, frankly, a lot of companies mislabel employees because they don't want to pay the benefits, which are quite expensive. Oh, let's see here. Yeah, you're being correct. I'm being a little lazy with my classification here. There are professional engineers and licensed engineers, and then there are consultants and professional and independent contractors, and there are subtle differences between all those words. Getting into all the distinction would have taken quite a bit of time, and that's not really the point. For the purposes of the rules, there are people that are employed by themselves who work with a company that I'm calling consultants. There are people that are employed by companies to work for the companies. I'm calling them employees, just to simplify this. St. James is raising some points regarding government employment, which is complicated. But the government, of course, complies with these rules too. And if the General Services Administration or Department or DHL is violating these rules, then the government can be in violation too. Let's see, Unix dev. My company does not perform personal services in that it can put any qualified person on the job. Independent contractor status. I don't quite understand what you mean by that. What do you mean? I'm not sure what you mean by personal services here. They can put any qualified person on the job. Actually, that argues against the existence of specialized skills. If anybody can do it, it doesn't require specialized skills to be done. Now, there's a lot of other factors that would come into play here, but the skill needs to be specialized. And again, the basic bias here, this is a gross generalization, but the general bias here is that the more skill required to do a job, the more likely it is that you're a consultant. Being highly skilled in and of itself doesn't make you a consultant, but it's a step in the right direction. Okay, I skipped over a couple things because I thought they were getting repetitive, which is fine. If I didn't respond to a question that you have, hold on, let me get to the front here. There we go. Again, my email address is r.t.harrison@ieee.org. My phone number is 202-530-8326. Feel free to give me a call. Just want to remind you that I am not an attorney. I cannot give you legal advice, and I cannot give you a ruling on your particular employment situation or a particular contractual situation. I can tell you what the rules say. I can tell you what the Department of Labor is doing. I can tell you what Congress is doing. But to get a ruling on your specific situation, you're going to have to contact an attorney. I want to thank you all for joining us today. On behalf of IEEE-USA, I hope you have a great Thursday and a lovely fall. Have a great afternoon.